Case 1. Betty Sue Snider. Discovered August 29, 2024, Jefferson County District Court, Louisville, Kentucky. There are communities all across this country that carry stories the rest of the world never hears. Stories that live inside court records, inside child welfare reports, inside the quiet hallways of schools where staff members notice something that nobody else has caught yet. Louisville, Kentucky, a city defined by its riverfront history, its deep community roots, its reputation for resilience, carries some of those stories too. And the story of what happened to 3 children in a Louisville area mobile home is one that speaks not just to the failure of one individual, but to the courage it takes for a community to protect its most vulnerable members when the people who should be doing that protecting have failed entirely. The story begins not with a police call. It does not begin with a neighbor's tip or a social worker's report. It begins with a 16-year-old girl who could not make it through a school day. In the final days of August 2024, staff members at a Louisville area school encountered a student in a condition that stopped them cold. A teenage girl, 16 years old, had not made it to class that morning. When school administrators located her, she was on the floor of a school restroom. Not resting, not taking a break. She was there because her body had been so severely deprived of proper nutrition and hydration that she could no longer sustain herself through an ordinary school day. She was severely malnourished. She was severely dehydrated. The physical condition of this child told a story that words alone could barely contain. A story of months of deprivation, of a home environment so profoundly unsafe that her body had begun to break down under the weight of it. School administrators contacted authorities without hesitation. That single decision, that single phone call made by people who took their responsibility to that child seriously, set in motion everything that followed. Louisville Metro Police officers responded to conduct a welfare check at the family's mobile home. Officers arrived at the property on August 29, 2024, prepared to assess the safety of the remaining children in the household. What they encountered when they stepped onto that property was a scene that investigators would later describe in court documents with language that still carries weight no matter how many times it is read. The interior of the mobile home was packed with trash, heavily infested with insects. The conditions inside that trailer were not marginally substandard. They were not the result of a hard week or a difficult month. They represented a living environment that had deteriorated to the point where no child, no person, should have been expected to occupy it. And yet the most disturbing discovery made by those officers that morning was not inside the trailer at all. It was in the backyard. Betty Sue Snider's 2 younger children, a 10-year-old and an 11-year-old, were not found in any room of the home. They were found living beneath a backyard gazebo, covered by tarps strung across the structure to create the most basic form of shelter imaginable. No electricity, no running water, no protection from the heat, the rain, or anything else the Kentucky summer had delivered to that backyard over the preceding months. According to court records and the findings documented by Louisville Metro Police investigators, those children had been forced to sleep outside for several months prior to the day police arrived. This was not an isolated incident. This was not a temporary situation that had gotten out of hand. This was the sustained, daily reality of these children's lives, a reality in which their mother occupied the interior of that home while they existed beneath tarps in a backyard. The contrast that this established, a mother inside, children outside, a parent sheltered, children exposed, is one that the court would ultimately be asked to weigh and respond to with the full authority of Kentucky law. And respond it did. The children were removed from the property and placed in protective care. The investigation by Louisville Metro Police was thorough and well documented. Investigators gathered every piece of evidence available. The physical conditions of the property, the medical condition of the children, the duration of the circumstances, the totality of what had been allowed to happen under that roofline and beneath those tarps. Prosecutors in Jefferson County reviewed the complete case file. The charges brought forward were serious, specific, and reflective of the scope of what had been allowed to happen to these 3 children over an extended period of time. The case moved through Jefferson County District Court over the months that followed. Betty Sue Snider's legal representation and the prosecution reached a resolution that brought the case to its legal conclusion. On July 10, 2025, nearly 11 months after police first stepped onto that property, Betty Sue Snider appeared before a Jefferson County judge and entered what Kentucky law recognizes as an Alford plea. For anyone unfamiliar with this legal instrument, an Alford plea is a specific type of plea in which the defendant does not formally admit personal guilt but acknowledges that the prosecution has assembled sufficient evidence to obtain a conviction at trial. It is, in the simplest terms, a legal concession that the facts on record speak loudly enough on their own. The evidence in Betty Sue Snider's case spoke loudly enough. She entered that Alford plea to 11 counts of child endangerment and abandonment. 11 counts, each one a discrete, documented legal charge representing a specific aspect of the harm and deprivation that prosecutors established had been inflicted upon 3 children over an extended period. 11 times, the legal system drew a line and said, "This was wrong. This caused harm. This will be answered for." The sentence handed down by the Jefferson County Court was 3 years in a Kentucky State Correctional Facility. 3 years. The legal system made its determination, weighed the evidence, and delivered its verdict in the form of a sentence that will remain on the public record of Jefferson County, Kentucky, alongside the names of 3 children who survived what was done to them because a school staff member made the right call on an August morning in 2024. Those children are out of that backyard now. They are away from those tarps. They are away from the trash-filled trailer and the insects and the months of sleeping on the ground while their mother remained inside with whatever shelter and comfort that home provided. They are in protective care, and whatever road lies ahead for them, it does not include that backyard. The child welfare and advocacy community in Louisville and across Kentucky has long emphasized a truth that this case illustrates with painful clarity. Child neglect does not always present itself as a visible emergency. It does not always arrive with sirens or obvious physical evidence in public spaces. Sometimes it looks like a teenager who cannot make it through a school day. Sometimes the only voice these children have is a teacher, a counselor, a cafeteria worker, an administrator who pays attention and trusts what they see. For the children of Betty Sue Snider, that voice existed. The system responded, and the Jefferson County Court delivered accountability. If you are ever concerned about the welfare of a child in your community, please know that the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week, at 1-800-4-CHILD. That is 1-800-422-4453. One call can change a child's life entirely. One call, made by someone paying attention, already changed the lives of the children in this case. Betty Sue Snider was sentenced to 3 years in Jefferson County. The legal record stands. 3 children who once slept under tarps in a Louisville backyard are safe today because someone in a school hallway refused to look the other way. Justice matters. These children's stories matter. If this case moved you, if it reminded you of why community accountability is so important, please take a moment right now to like this video, leave a comment, and subscribe to Cold Case Hour. Every single subscription tells this platform that stories like this one deserve to be heard. Hit that subscribe button and stay with us, because there are 9 more cases in Louisville that demand your attention. Case 2, Tiffanie Lucas. November 8, 2023 Bullitt County Circuit Court, Shepherdsville, Kentucky. Shepherdsville, Kentucky, sits in Bullitt County just south of Louisville along the Interstate 65 corridor, close enough to the city that its residents move fluidly between the suburban community and the metropolitan area, sharing schools, workplaces, shopping centers, and the rhythms of daily life that define the greater Louisville region. It is the kind of community where neighbors know each other's routines, where a sound out of place on a quiet street at night carries and registers in the minds of the people who hear it. On the evening of November 8, 2023, a sound carried through the walls of a residential home in Shepherdsville and reached the ears of a neighbor. The neighbor heard gunshots. And unlike the instinct that sometimes causes people to convince themselves they misheard, to rationalize away what they know they heard, this neighbor did not hesitate. They went to investigate. They entered the home. And what they found inside that bedroom is something that no person who has not lived through that kind of discovery can fully comprehend. 2 young children, who had been living their lives just hours before, were gone. Maurice was 6 years old. Jaden was 9 years old. They were brothers. They were Tiffanie Lucas's sons. And on November 8, 2023, inside their bedroom in a Shepherdsville home, their mother used a firearm, and neither of them survived what happened in that room that night. Law enforcement responded immediately. Officers from Bullitt County arrived at the scene, secured the location, and began gathering the evidence that would form the foundation of the legal case that followed. Tiffanie Lucas was present at the scene when officers arrived. She was taken into custody without incident. The investigation that unfolded in the hours and days that followed was conducted with the full resources of Bullitt County law enforcement, and the case file that was assembled left no ambiguity about what had occurred inside that home. Prosecutors in Bullitt County reviewed the evidence and made their determination. The charges brought forward were 2 counts of murder, 1 for Maurice, 1 for Jaden. 2 counts, 2 sons, 2 lives that had been building toward futures that would now never arrive. Maurice was in 1st grade or approaching it. He was at an age when the world is still mostly wonder, when the biggest concerns involve playgrounds and cartoons, and the simple joys of being a 6-year-old child in the world. Jaden was 9, old enough to be developing his own personality, his own interests, the particular set of preferences and quirks that make a 9-year-old boy himself and nobody else. They were at ages when childhood is supposed to be mostly safe, mostly bright, mostly full of the kind of ordinary moments that families collect and carry for the rest of their lives. The Bullitt County Circuit Court proceedings moved forward. The case was built on a body of evidence that prosecutors presented with clarity and comprehensiveness. As the legal process advanced, Tiffanie Lucas ultimately entered a guilty plea to both counts of murder. The Bullitt County Circuit Court accepted that plea and recorded the legal outcome that the evidence had always pointed toward. 2 counts of murder. Guilty. The court's record stands in Shepherdsville, in Bullitt County, in the greater Louisville metropolitan area that surrounds and encompasses these communities and their stories. The community that surrounds this case, the neighbors who heard what they heard and did not look away, the law enforcement officers who responded and did their jobs, the prosecutors who built and pursued a case that honored the memory of 2 children. Each of them played a role in ensuring that what happened to Maurice and Jaden was not simply absorbed into the anonymous silence that sometimes follows tragedy. They made sure it was documented, charged, and answered for. Child safety advocates and family crisis intervention professionals frequently point to cases involving young children as the most critical area for community awareness, not because older children matter less, but because children under 10 are almost entirely dependent on the adults in their lives for every dimension of their safety. They cannot remove themselves from danger. They cannot call for help. They rely entirely on the adults around them. And when those adults fail them at the most fundamental level, it is the community, the neighbor who pays attention, the system that responds, that represents their only protection. For Maurice and Jaden Lucas, the community responded. It came too late to save them, but it responded with clarity, with accountability, and with a legal outcome that made certain their names would be spoken in a courtroom, that their loss would be formally recognized, and that the person responsible would face the full weight of what the law demands. Tiffanie Lucas entered a guilty plea to 2 counts of murder in Bullitt County Circuit Court. Maurice was 6. Jaden was 9. Their names will not be forgotten here. If this story affected you, if it reminded you that accountability and community awareness go hand in hand, please like this video, leave a comment, and subscribe to Cold Case Hour. These children deserve to be remembered, and your subscription keeps these stories alive on this platform. Like, comment, and subscribe. We honor them by continuing. Case 3, Amber Winstead. January 1st, 2025, Jefferson County, Kentucky. The first hours of a new year carry a particular emotional weight. Across Louisville and across every city in this country, families gather, celebrate, and welcome the turn of the calendar with a sense of optimism that is as human as anything we do. January 1st is supposed to represent renewal. It is supposed to represent the particular hope that comes from closing one chapter and stepping forward into the next. In the early morning hours of January 1st, 2025, at approximately 4:40 in the morning, Louisville Metro police officers responded to a call at a Motel 6 located on Airport Hotel Boulevard in South Louisville. And what they found in that motel room marked the beginning of a case that would work its way through the Jefferson County legal system for the better part of a year before reaching its legal conclusion. Amber Winstead was 36 years old. She had a 3-month-old infant in her care that night. A baby. A child so young that the entire span of their existence, every single day they had ever been alive, every breath they had taken, Every moment they had spent in the world was contained within 90 days. 3 months old. At that age, an infant is entirely and completely dependent on the adult responsible for their care in a way that is total and absolute. They cannot feed themselves. They cannot move themselves. They cannot call for help or signal danger or do anything at all to protect themselves from any circumstance in their environment. They exist in a state of pure trust, the kind of trust that has no language behind it, the kind that is simply the biological condition of being new to the world and dependent on someone else for everything. Court records and investigative findings established the sequence of events that led to that 4:40 call on New Year's morning. Amber Winstead had been using narcotics throughout the course of December 31st into the early hours of January 1st. At some point during the overnight hours, she entered the motel bathtub with her 3-month-old infant while in an impaired state. She fell asleep in that bathtub. When another individual present in the motel room woke Winstead some hours later, the infant was submerged beneath the water in the bathtub. The baby was not breathing. Emergency responders were summoned. The infant did not survive. Louisville Metro police officers arrived, secured the scene, and began the investigative process that would ultimately lead to charges. The physical evidence gathered at the motel, the toxicological findings, and the account of what transpired that night were all documented and reviewed by Jefferson County prosecutors as they assembled the legal case. The case moved through Jefferson County Court over the months that followed that January morning. Amber Winstead was charged in connection with the loss of her infant child. The legal process advanced, evidence was presented, and on October 31st, 2025, exactly 10 months after Louisville Metro Police received that 4:40 call on New Year's morning, Amber Winstead appeared before a Jefferson County judge and entered a guilty plea to second-degree manslaughter. The court accepted the plea. Jefferson County recorded its legal outcome. Second-degree manslaughter. Guilty. A 3-month-old child. The full span of that infant's life was 3 months. 90 days. The weight of that number is something that does not diminish with time or with the clinical distance of legal proceedings. A baby who had been alive for 90 days did not survive the night of December 31st, 2024, because the one person in that motel room who was legally and morally responsible for that child's safety chose to enter a bathtub while impaired and fell asleep with an infant in the water. The public health conversation around substance use and infant safety is one that Louisville's health community, child welfare advocates, and pediatric care professionals engage with constantly and urgently, not because they believe that every parent who struggles with substance dependency is a danger to their children, but because the intersection of substance impairment and infant care represents one of the most well-documented areas of preventable infant harm that exists. The organizations and advocates working on these issues across Louisville and Jefferson County consistently emphasize a single core message. If you are impaired, your infant needs someone else. One phone call to a trusted family member, one decision to hand that child to someone who is in a safe condition to care for them, can be the difference between a story with a different ending and the story of January 1st, 2025. Amber Winstead pleaded guilty to second-degree manslaughter in Jefferson County on October 31st, 2025. The court recorded its verdict. A 3-month-old child who had been alive for just 90 days deserved far more than what that New Year's morning delivered. If this case speaks to you, if it moved you to think about the value of awareness and accountability, please like this video, drop a comment, and subscribe to Cold Case Hour. Your support keeps these stories on this platform and keeps these victims from being forgotten. Like, comment, and subscribe. We continue. Case 4, Dejaune Anderson. April 2022 Marion Superior Court / Washington County, Indiana. There are cases in the Louisville true crime record that extend beyond the city's boundaries. Cases that begin on Louisville streets and then travel across state lines. Cases that generate multi-year investigations. Cases that put federal law enforcement resources into motion and ultimately conclude in courtrooms hundreds of miles from where they began. The case of Dejaune Anderson and her 5-year-old son Cairo Jordan is one of those cases. It is a case that began in a Louisville apartment in April of 2022, wound through 2 states, drew the attention of federal marshals, and concluded with an arrest in California 2 years after the crime was committed. It is one of the most widely covered and deeply unsettling cases in Louisville's recent true crime history. Cairo Jordan was 5 years old. 5 years old is an age that carries a very specific quality of childhood, old enough to be curious about the world in a genuine, expansive way, old enough to have developed a personality that the people around him would have recognized and remembered, old enough to have started building the foundation of memories and experiences and relationships that are supposed to accumulate across a lifetime. Cairo Jordan was at the beginning of all of that. He was 5 years old, living in a Louisville apartment, and in April of 2022, he lost his life at the hands of his own mother. Dejaune Anderson caused the loss of her 5-year-old son Cairo Jordan inside their Louisville apartment. The precise details of how Cairo Jordan lost his life were documented through the investigative process and court proceedings that followed. What is established by court records is that after Cairo Jordan's life ended in that apartment, Dejaune Anderson made a series of decisions that transformed an already devastating act into one of the most disturbing cases of its kind in Louisville's modern history. She packed Cairo Jordan's remains into a suitcase. Not any suitcase. A distinctive, hard-shell suitcase with a Las Vegas theme, a piece of luggage that was visually identifiable in a way that would ultimately prove significant to the investigation. She placed that suitcase in her vehicle, drove north from Louisville, crossed the Ohio River, and continued into southern Indiana. In Washington County, Indiana, in a wooded area removed from population centers, she left that suitcase among the trees and drove away. She then continued her life. She moved. She traveled. By the time law enforcement caught up with her, she had made her way entirely across the country to California. The discovery of the suitcase and the remains of Cairo Jordan set off an investigation that drew resources from multiple law enforcement agencies across 2 states. The distinctive appearance of that Las Vegas-themed hard-shell suitcase became a critical element of the investigation, a physical description that was shared publicly, that generated tips, and that helped investigators begin building the evidentiary trail that ultimately led back to the Louisville apartment and to Dejaune Anderson. The investigation spanned 2 years. It involved Louisville Metro Police, Indiana law enforcement authorities, and ultimately federal marshals. The multi-jurisdictional nature of the case, a crime committed in Kentucky, remains transported to Indiana, a suspect eventually located in California, required coordination across multiple law enforcement systems, and the application of federal resources to locate and apprehend a suspect who had put significant distance between herself and what she had done. In March of 2024, nearly 2 full years after Cairo Jordan lost his life in that Louisville apartment, federal marshals located Dejaune Anderson in California and took her into custody. She was extradited to Indiana to face the legal proceedings that Washington County and Indiana prosecutors had prepared in connection with the discovery of Cairo Jordan's remains and the evidence assembled across 2 years of investigation. The charges brought against Dejaune Anderson were serious and comprehensive: murder, neglect of a dependent, and abuse of a corpse. Each charge addressed a distinct dimension of what the evidence established had happened: the act that ended Cairo's life, the failure that defined the circumstances leading to that act, and the decisions made afterward to conceal what she had done. Cairo Jordan was 5 years old. His name, Cairo Jordan, is the kind of name that carries weight. It is specific. It is individual. It belongs to a child who had a life, however brief, that was entirely his own. A child who had a face, a voice, preferences, moments of joy and curiosity that the people who knew him would have recognized. He deserved every year that should have followed his 5th. He deserved to grow up. He deserved the protection of the one person in his life whose entire legal and moral obligation was to ensure exactly that. The legal proceedings in Indiana continued following Anderson's extradition. The case, built on 2 years of multi-state investigation, stands as one of the most significant accountability efforts in recent Louisville area true crime history, not only because of the severity of the charges, but because of the years of persistent, coordinated law enforcement work that made the arrest possible despite the geographic distance Anderson had placed between herself and the crime. 2 years. Federal marshals. A cross-country arrest. A Las Vegas-themed suitcase left in the Indiana woods. These are the details of a case that represents not only the horror of what was done to a 5-year-old child in a Louisville apartment, but also the unwavering commitment of law enforcement to pursue accountability regardless of how far a suspect runs or how much time passes. Cairo Jordan was 5 years old. His name is on the record. The investigation found him. The law followed where it led. If this case reached you, if Cairo's story stayed with you, please like this video, leave a comment, and subscribe to Cold Case Hour. Justice takes time, but it comes. Your subscription keeps these cases in front of people who need to hear them. Like, comment, subscribe. For Cairo. Case 5, Billi Joe Smallwood. May 29, 2003 U.S. District Court for the Western District of Kentucky, Louisville. Among the 10 cases documented in this episode, the case of Billi Joe Smallwood stands in a category that is singular in one very specific and important way. It is a federal case. It was investigated and prosecuted not by Jefferson County or any Kentucky state court, but by the United States District Court for the Western District of Kentucky, headquartered in Louisville, under federal law, with federal charges, and a federal sentence that reflects the gravity of what the evidence established about the events of May 29, 2003, on the grounds of Fort Knox military installation. Fort Knox is one of the most recognizable names in American military and financial history. Located in Hardin County, Kentucky, it sits within the broader Louisville metropolitan region and has been an active United States Army installation for over a century. Military families assigned to Fort Knox live in on-base housing units, structured residential communities governed not by Jefferson County ordinances or Kentucky state building codes, but by federal military housing regulations and, critically for the purposes of this case, federal law. Billi Joe Smallwood was a member of a military family living in one of those on-base housing units at Fort Knox in the spring of 2003. She was a mother. Her daughter Simone was 3 years old. Her son Caleb was 2 years old. Her husband lived in that housing unit with her. They were a family living on a military base in federal housing, under a roof that was supposed to represent safety, the particular safety of a structured community with resources and oversight that civilian neighborhoods sometimes lack. On May 29, 2003, Billi Joe Smallwood intentionally set fire to that housing unit. The fire that she started in that on-base housing unit spread with the speed and force that fire always carries when it is given the materials and space to move. 3-year-old Simone did not survive the fire. 2-year-old Caleb did not survive the fire. Billi Joe Smallwood's husband suffered severe burns in the blaze. The investigation that followed established, through physical evidence and the forensic reconstruction of the fire's origin and spread, that the fire was deliberately set, that it was not an accident, not a malfunction, not a tragedy of circumstance. It was an act of intentional arson. Because the crime occurred on a federal military installation, on federal property governed by federal jurisdiction, the case was not handled by Kentucky state prosecutors or Jefferson County courts. It was handled by federal investigators and prosecutors operating under the authority of the United States government. The case was brought before the United States District Court for the Western District of Kentucky, which sits in Louisville and holds jurisdiction over federal criminal matters arising in the western portion of the state. Billi Joe Smallwood was charged under federal law with malicious arson resulting in death. The charge is as precise as it sounds, an act of deliberate fire setting, motivated by malice, that resulted in the loss of human life. Federal prosecutors built their case on the investigative findings, the physical evidence from the fire scene, and the expert forensic analysis that established the fire's intentional origin. The federal trial proceeded. The evidence was presented. The jury heard the case. Billi Joe Smallwood was convicted of malicious arson resulting in death. The federal court sentence was life in prison, not a fixed term, not a number of years with the possibility of early release under standard guidelines. Life in federal prison. A sentence that reflects the federal court's assessment of the severity of what the evidence established, and that reflects the particular weight that the United States government places on crimes that result in the loss of life, particularly the lives of children. Simone was 3 years old. Caleb was 2 years old. Together, they had 5 years of life between them. 5 years. A 3-year-old and a 2-year-old. Children who were still learning what the world was, still discovering the particular textures and sounds and colors of being alive, still entirely dependent on the adults in their lives for every dimension of their safety and survival. They were in a home that was set on fire deliberately. They were in a home where the person who made that choice was the one person in the world whose entire purpose in relation to them was protection. Billi Joe Smallwood is serving a life sentence in a federal correctional facility. The United States District Court for the Western District of Kentucky, Louisville, recorded its verdict more than 2 decades ago, and that verdict has never changed. She will not be released. The federal system drew a line and held it. The Fort Knox community, the military families who live on that installation, the broader Louisville metropolitan region in which Fort Knox sits, all of them were affected by the events of May 29, 2003. Military installations, for all of the structure and oversight they provide, are still communities made up of families. And families, wherever they live, carry both the potential for love and the potential for its devastating failure. This case endures in the historical record of Louisville area federal prosecution as a reminder that federal jurisdiction exists precisely to ensure that crimes of this severity are pursued with the full weight of the United States government behind the investigation and prosecution, regardless of how much time passes, regardless of the circumstances, regardless of any other factor. The federal court spoke. The sentence stands. Simone and Caleb are remembered. These children deserve to be remembered by more than a court record. Please like this video, leave a comment, and subscribe to Cold Case Hour. Every subscription, every like, every comment tells this platform that these stories matter and should continue to be heard. Like, comment, and subscribe. For Simone and Caleb. Case 6, Kaitlyn Higgins. April 19, 2021 Jefferson County Circuit Court, Louisville, Kentucky. The call came into Louisville Metro Police on the morning of April 19, 2021. Neighbors in the area of Algonquin Parkway, a residential street in Louisville's South End, had observed something that alarmed them enough to contact law enforcement immediately. A woman was on the front porch of a home with a firearm. That call brought officers to the scene. And what those officers discovered when they arrived at that address would unfold across the next several hours into one of the most disturbing and heartbreaking investigations Louisville Metro Police had handled in years. Officers arrived on Algonquin Parkway and immediately observed physical evidence at the scene. There was blood on the front steps of the home. The presence of that evidence escalated the response and expanded the scope of what officers needed to investigate. A search of the property, including Kaitlyn Higgins's vehicle parked outside, led investigators to the most devastating discovery of the entire scene. In the trunk of Kaitlyn Higgins's vehicle, wrapped in a blanket, was the body of her 10-year-old son. His name was Kaitlyn Higgins Jr. He was 10 years old. He had been placed in that trunk, covered, and left there. Kaitlyn Higgins was taken into custody. The investigation that followed was comprehensive and extended over the course of the legal proceedings that ensued. The case generated significant documentation, including extensive court evaluations and psychological assessments that formed a critical part of the legal record. What those court proceedings and evaluations established, through professional psychological assessment, forensic review, and the full evidentiary record, was that Kaitlyn Higgins had been experiencing a severe, methamphetamine-induced psychotic episode in the hours surrounding Kaitlyn's death. The clinical and legal documentation of that psychotic state described a condition so profound and so disconnected from rational reality that evaluators' findings became central to the legal proceedings and the court's assessment of the case. The details of what occurred inside that home on Algonquin Parkway before officers arrived are documented in court records and professional evaluations that were entered into evidence during the proceedings. The substance of what those records describe, the nature of the harm inflicted on Kaitlyn Higgins Jr. in the context of that severe psychotic state, is something that the Jefferson County court system addressed with the full gravity it demanded. Kaitlyn Higgins Jr. was 10 years old. He was at an age when children begin to develop a real sense of independence, when 5th grade or the approach of middle school is starting to shape how a child sees themselves in the world. He was at an age when a 10-year-old boy has opinions, has friendships, has a growing sense of who he is. He was somebody. He was real and specific and entirely deserving of the years that should have followed his 10th. The case moved through Jefferson County Circuit Court with the kind of careful, comprehensive legal attention that the severity of the evidence demanded. The methamphetamine-induced psychosis documented in court evaluations was a central factor in the legal proceedings, not as a path to dismissal, but as a critical element of the court's responsibility to understand the full circumstances of what occurred on April 19, 2021. The Jefferson County Circuit Court proceedings addressed both the circumstances of Kaitlyn's death and the legal accountability of the person responsible for it. The court record in this case stands as documentation not only of the specific tragedy on Algonquin Parkway, but of the intersection of severe substance-induced mental health crisis and the catastrophic consequences that can result when that crisis goes unaddressed and children are present. The public health and child welfare conversation around substance use, mental health intervention, and the safety of children in households affected by these issues is one that Louisville's advocacy community engages with constantly. Organizations working in this space consistently emphasize that substance-induced psychosis is a recognized, documented medical crisis, and that the systems designed to identify and intervene in these crises exist precisely because the stakes, when they go unaddressed, can be measured in the lives of children who had no say in the circumstances they were placed in. Kaitlyn Higgins Jr. was 10 years old. His name belongs on the record. The Jefferson County Circuit Court recorded its proceedings, its evaluations, and its legal determination. The case of Kaitlyn Higgins stands in Louisville's true crime history as a case in which the court system was asked to grapple with the most difficult intersection of criminal accountability and documented mental health crisis, and responded with the full weight of its legal authority. If Kaitlyn's story affected you, if it reminded you how important mental health resources and child protection systems are, please like this video, leave a comment, and subscribe to Cold Case Hour. We keep these stories alive because the victims deserve to be more than a forgotten case file. Like, comment, and subscribe. Case 7. Gail Lynn Kuntz. July 1988 Jefferson County Circuit Court, Louisville, Kentucky. Some cases in the Louisville true crime record are not recent. They did not happen in the age of social media, of live-streamed police scanners, of case updates pushed to smartphones in real time. They happened in a different era, were covered by a different media landscape, and were processed by a justice system that has changed significantly in the decades since. But the facts of those cases, the lives that were lost, and the legal outcomes that resulted do not diminish with time. They remain in the court record. They remain in the historical memory of a city. They remain in the parole board hearings that have, year after year, brought the name Gail Lynn Kuntz back before the Kentucky Parole Board and produced the same answer every time. The story of Gail Lynn Kuntz begins in July of 1988 in Louisville, Kentucky. It involves two children, Greg, who was 14 years old, and Nikki, who was 10 years old. It involves their home, which should have been the place in the world where they were safest. And it involves their mother, Gail Lynn Kuntz, who on a July day in 1988 used a firearm to end both of their lives inside that home. Greg was 14. He was a teenager, old enough to have a real sense of himself, old enough to have interests and friendships, and a developing understanding of the world and his place in it. He was at that particular stage of adolescence when the future begins to feel both real and possible, when the things a person wants from life start to take shape in ways that are distinct and personal. He was 14, and he had his whole life in front of him. Nikki was 10. She was a child in every sense of the word, in the middle of elementary school, at an age when childhood is supposed to be characterized by the kind of uncomplicated security that lets a kid just be a kid. She was 10 years old, and she had no ability to anticipate or prevent what her mother did in their home that July day. Gail Lynn Kuntz caused both of her children to lose their lives inside that Louisville home. She was arrested. The investigation established the facts of the case with the clarity and comprehensiveness that the Jefferson County Circuit Court required. Prosecutors brought charges of 2 counts of murder, one for Greg, one for Nikki. The Jefferson County Circuit Court proceedings moved forward. The evidence was presented. The jury heard the case. Gail Lynn Kuntz was convicted of 2 counts of murder. The court handed down a sentence of life imprisonment. The verdict was entered into the record of Jefferson County, Kentucky, in 1988, and the legal consequence that followed has remained in place, albeit tested, across the nearly 4 decades since. The testing of that consequence has come through the Kentucky parole system. Under Kentucky law, individuals serving life sentences become eligible for parole consideration after serving a minimum number of years, in this case, after 25 years of imprisonment. Gail Lynn Kuntz became parole eligible after serving those 25 years. The Kentucky Parole Board was required by law to consider her case. They have considered it more than once. And more than once, the answer has been the same. The Kentucky Parole Board has repeatedly denied Gail Lynn Koontz's release. The board, which reviews parole applications based on a comprehensive assessment of the circumstances of the crime, the nature of the conviction, the conduct of the incarcerated individual, and the risk posed to public safety upon release, has looked at the record of July 1988 in Louisville, looked at the 2 children who lost their lives in that house, and determined, on each occasion it has been asked, that release is not warranted. Greg and Nikki Kuntz, a 14-year-old and a 10-year-old. Their names are in the Jefferson County Circuit Court record from 1988. Their names are in the Kentucky Parole Board records from the hearings that followed their mother's parole eligibility. Their names belong in every account of this case, because they are the reason the case exists, not the legal proceedings, not the parole hearings, not the years of incarceration. Them, Greg and Nikki, 2 children who deserve to grow up. The case of Gail Lynn Kuntz stands in Louisville's historical true crime record as one of the oldest and most enduring accountability stories in the city's modern legal history. Nearly 4 decades have passed since that July day in 1988. The legal system made its determination. The parole board has repeatedly affirmed that determination. The record stands. What this case also represents, in the broader context of historical child homicide cases in Louisville, is the long memory of the justice system. Cases like this one do not disappear. They do not age out of relevance. They remain in the record, in the parole board's review process, in the court documents that any researcher or journalist can access. A permanent, public acknowledgement that what happened to Greg and Nikki Kuntz happened, that it was answered for, and that the system continues to revisit that answer on a regular basis to ensure it remains correct. The parole board has said no. Year after year, the record continues. Greg and Nikki's story is part of Louisville's history, and it deserves to be told. Please like this video, leave a comment, and subscribe to Cold Case Hour. Your support keeps these cases visible and these victims remembered. Like, comment, and subscribe. Their names deserve to be heard. Case 8, Zeinab Abdi. June 19, 2025 Jefferson County Circuit Court, Louisville, Kentucky. The Park Duval neighborhood in Louisville's West End is a community that has seen significant investment and revitalization effort in recent years, a residential area characterized by a mix of housing types and a population with deep roots in the city's West End identity. It is a neighborhood where residents live close to one another, where community is built through proximity and shared daily life, and where the sounds of a household can carry through the walls and windows of neighboring homes with relative ease. On June 19, 2025, Louisville Metro Police received a call classified as a trouble run, a call type that indicates a disturbance or emergency situation requiring immediate officer response, at an address in the 2900 block of Wilson Avenue in Park Duval. Officers responded. What they encountered at that address, and what the investigation and subsequent indictment established, represents one of the most alarming cases of family violence in Louisville's 2025 true crime record. Zeinab Abdi was 40 years old. Her 6-year-old daughter was present in the home on Wilson Avenue on June 19, 2025. According to the investigative findings and the indictment that followed, Abdi attacked her 6-year-old daughter inside that home, striking the child in the head with a hammer multiple times. A hammer, used against a 6-year-old child, multiple times. The precision of that detail, the specific, deliberate nature of the instrument and the repetition of the act, is something that the Jefferson County indictment documented with clarity, and something that the court record will carry forward through the legal proceedings that follow. The attack was stopped, not by responding officers, though they arrived quickly. It was stopped by someone already present in the home, Abdi's son, who physically intervened and restrained his mother to prevent the attack from continuing. In the moment of that restraint, as her son held her back from her daughter, Zeinab Abdi told him, "Let me finish her." For words, "Let me finish her," directed at a son who had just physically stopped his own mother from continuing to harm his 6-year-old sister. Those 4 words are part of the court record. They are part of the indictment. They will be part of whatever legal proceedings follow. Emergency services were summoned immediately. The 6-year-old girl was transported to a Louisville medical facility. Medical staff who treated her documented the injuries she had sustained. Injuries that included severe skull fractures and significant bleeding affecting her brain. The child had sustained injuries of a severity that required immediate and intensive medical intervention. She survived. Against the severity of what she endured, she survived. Louisville Metro Police investigators conducted their investigation thoroughly. The evidence gathered at the scene on Wilson Avenue, the medical documentation of the child's injuries, the account of the son who intervened, and the statement attributed to Abdi in the moment of restraint all formed the body of evidence that Jefferson County prosecutors reviewed in building the indictment that followed. In August of 2025, approximately 6 weeks after the events of June 19, Zeinab Abdi was indicted by a Jefferson County grand jury on 3 charges: attempted murder, first-degree assault, and first-degree criminal abuse. Each charge addresses a distinct dimension of what the evidence established occurred in that Park Duval home on June 19, 2025. The legal proceedings in Jefferson County Circuit Court were ongoing as of the most recent available record. The indictment has been entered. The charges are serious. The evidence assembled by Louisville Metro Police and reviewed by Jefferson County prosecutors reflects an account of events that is documented, specific, and legally actionable. The 6-year-old girl in this case survived. That fact, while it cannot erase what she endured, cannot undo the trauma and the physical harm, is the fact that the community surrounding this case holds on to most tightly. She survived. She is alive. She is away from Wilson Avenue and away from the circumstances of June 19, 2025. Whatever road of recovery lies ahead for her, she has the chance to walk it. Her brother, the son who stepped between his mother and his sister, who physically restrained an adult woman to stop an attack on a 6-year-old child, acted with a clarity and a courage that the circumstances of that moment demanded, and that his sister's survival required. That act of intervention is part of the record too. It is part of the story of June 19, 2025, in Park Duval, and it deserves to be acknowledged. Zeinab Abdi was indicted in Jefferson County in August of 2025 on charges of attempted murder, first-degree assault, and first-degree criminal abuse. The case continues. The 6-year-old girl survived. This little girl survived, and she deserves every chance at a full life ahead. Please like this video, leave a comment, and subscribe to Cold Case Hour. Every view, every like, every subscription keeps this platform supporting content that holds people accountable and honors the children who endure the unthinkable. Like, comment, and subscribe. Case 9, Shelby Kuntz. Discovered January 15, 2026, Jefferson County Circuit Court, Louisville, Kentucky. There is a particular category of case in child protective services and emergency medicine that professionals describe as the most difficult they ever encounter. Cases in which a child arrives at a medical facility in a condition that tells a story no parent's words can override or explain away. Cases in which the physical evidence of what a child's body has endured is so comprehensive, so multi-layered, and so inconsistent with any accidental explanation that the medical staff who receive that child know, from the moment of arrival, that what they are looking at is the result of deliberate, ongoing, and severe harm inflicted on a child who had no one in their world capable of stopping it. On January 15, 2026, a 2-year-old child was brought to a Louisville medical center in full cardiac arrest. Emergency medical staff immediately began resuscitative efforts. The child was stabilized. In the medical examination that followed, the comprehensive clinical assessment of a 2-year-old whose heart had stopped revealed a picture of physical harm so extensive that the medical team contacted law enforcement before the initial examination was complete. The injuries documented by medical staff at that Louisville facility were numerous, specific, and catastrophic in their combined effect on a child's body. A fractured skull, broken ribs, missing teeth that had been present and were now gone, internal organ damage, severe emaciation. The child's body bore evidence of injuries that spanned multiple systems, skeletal, dental, internal, in a pattern that medical professionals and investigators recognized as reflecting not a single incident, but an ongoing pattern of severe physical harm inflicted over a period of time. 25-year-old Shelby Kuntz and her partner, 27-year-old Nicholas Shanks, were the adults responsible for the care of this 2-year-old child. They were the ones who had brought the child to the medical center. They were the ones whose home represented the environment in which this child's injuries had been sustained. Louisville Metro Police investigators were contacted by medical staff, responded to the hospital, and then did what investigators do when the evidence at a hospital points to ongoing harm in a household. They went to the home. What investigators found when they entered the South End residence shared by Shelby Kuntz and Nicholas Shanks compounded what was already a deeply serious situation into something that extended the scope of the case significantly. In that home, investigators located a 1-year-old child, the 2-year-old sibling. The 1-year-old, a baby by any definition, was also found to be suffering from injuries that required immediate medical attention. That 1-year-old had sustained skull fractures and a broken jaw. A baby, not yet old enough to speak, not yet old enough to understand what was happening around them, had sustained injuries to their skull and their jaw in the home they shared with their sibling and the adults legally responsible for both of them. Both children were removed from the home and transported to medical care. Louisville Metro Police investigators continued their work. Shelby Kuntz and Nicholas Shanks were arrested. The paternal grandmother, also connected to the household, was arrested as well. All three were held on bonds set at $500,000 each. The bond amounts reflect the court's assessment of the severity of the situation and the nature of the evidence assembled by investigators. The case continued to develop in the weeks that followed. In February of 2026, approximately 1 month after the initial discovery, prosecutors added additional charges to the case that extended its scope beyond the harm inflicted on the 2 children in that home. Those additional charges involved severe animal cruelty and the documented mistreatment of animals also present in the residence. The expansion of the charges to include animal cruelty is consistent with a body of research in criminal psychology and child welfare that has long established a documented connection between the abuse of animals in a household and the abuse of children in the same environment. When investigators and prosecutors encounter evidence of both, the additional charges are not merely supplemental. They reflect a more complete picture of the conditions that existed inside that home. The Jefferson County Circuit Court proceedings in this case were ongoing as of the most recent available record. The charges are serious. The evidence assembled by Louisville Metro Police and reviewed by Jefferson County prosecutors is comprehensive. 2 children, a 2-year-old and a 1-year-old, are alive today because a medical team responded quickly, because investigators followed the evidence from the hospital to the home, and because the child welfare system intervened to remove both children from a household that had failed them profoundly and repeatedly. The advocacy and child welfare community in Louisville has long engaged with the reality that cases of this nature, cases involving very young children, multiple victims within the same household, and a pattern of harm rather than a single incident, represent some of the most complex and resource-intensive investigations and prosecutions in the child protection system. The organizations, medical professionals, investigators, and prosecutors who work these cases do so with an awareness that each child they are working to protect has a name, a face, and a future that depends entirely on the system functioning the way it is supposed to function. For the 2 children on South End, the system functioned. It was a medical center that saw the evidence and called law enforcement. It was investigators who went to the home and found the second child. It was a court that set serious bonds and prosecutors who continued to build the case month by month. It is a system that, in this instance, moved. Both children are receiving care. The legal process continues. Shelby Kuntz, Nicholas Shanks, and the paternal grandmother face serious charges in Jefferson County Circuit Court. These 2 babies deserved better from every adult in their lives. Please like this video, leave a comment, and subscribe to Cold Case Hour. Your subscription supports content that centers these children and demands accountability for the people who failed them. Like, comment, and subscribe. Case 10, Daira Mejia, Aguilar. July 2nd, 2024 Jefferson County Circuit Court, Louisville, Kentucky. The 700 block of Zorn Avenue sits in Louisville's Crescent Hill neighborhood, a residential area on the eastern edge of Louisville proper, characterized by tree-lined streets, a mix of historic and mid-century housing stock, and the kind of neighborhood density that places residents in reasonable proximity to one another while still preserving the relative privacy that apartment living provides. It is not the kind of neighborhood that typically generates the sort of investigation that Jefferson County law enforcement conducted in the first week of July 2024. But on July 2nd of that year, something happened inside an apartment on Zorn Avenue and the discovery of what that something was would unfold across the following 5 days in a series of investigative steps that ultimately led to an arrest and a felony charge in Jefferson County Circuit Court. Daira Mejia Aguilar was 22 years old in the summer of 2024. On July 2, 2024, she gave birth to a full-term infant inside her Zorn Avenue apartment. The birth was not attended by medical professionals. It was not registered. It did not generate the documentation, the hospital records, the birth certificate filings, the discharge paperwork that accompanies nearly every birth in this country under normal circumstances. It happened in private, in an apartment, and the infant that was born on July 2, 2024, was a full-term baby, not premature, not medically fragile in the way that some unexpected home deliveries involve. A full-term newborn, alive, born in an apartment on Zorn Avenue. What Daira Mejia Aguilar did next is documented in the investigative record and the subsequent legal proceedings. She wrapped the newborn in a blanket. She placed the wrapped infant inside a trash bag. She carried that bag to her closet and concealed it there. Days passed. A tip came in to Louisville Metro Police indicating that something may have occurred in connection with that Zorn Avenue apartment. Officers responded. When they entered the apartment and examined the closet, what they found was a space that bore the unmistakable physical evidence of a birth having occurred there, blood-stained surfaces, and conditions that investigators documented as consistent with the account that would later emerge. What they did not find in the closet was the infant. Because by the time officers arrived to investigate the tip, Daira Mejia Aguilar had moved the trash bag from the closet to the trunk of her car. The investigation continued. Louisville Metro Police obtained a search warrant and conducted a search of Mejia Aguilar's vehicle on July 7, 2024, 5 days after the infant's birth. In the trunk of that car, in that trash bag, investigators found the remains of the newborn. The infant had been there, in the heat of a Kentucky July, for days. The legal proceedings that followed addressed the specific charges available to Jefferson County prosecutors under Kentucky law based on the evidence assembled. Daira Mejia Aguilar was charged with a felony count of abuse of a corpse. The charge reflects what the evidence established: the handling and concealment of the remains of a newborn infant in circumstances that the law recognizes as criminal. The case of Daira Mejia Aguilar raises, in the most urgent and compassionate terms possible, the conversation about safe haven laws, a conversation that child advocacy organizations and public health professionals in Louisville and across Kentucky have engaged in for years. Kentucky, like every state in the United States, has a safe haven law. In Kentucky, that law is called the Safe Surrender Law, and it allows a parent to surrender a newborn infant, safely, legally, and without fear of criminal prosecution, at any hospital, any fire station, or any other designated safe surrender location in the state, at any time, within the first 30 days of the infant's life. No questions, no arrest, no prosecution. A parent who is in crisis, who cannot care for a newborn, who finds themselves in circumstances that feel impossible, that parent has a legal, safe, protected option. The infant receives immediate medical care. The parent is not charged. The law was written precisely because the alternative, the outcome that occurred on Zorn Avenue, is a preventable tragedy, and the legal system recognized that prevention is better than prosecution. Had Daira Mejia Aguilar known about Kentucky's safe surrender law, had she had access to the information, the support, the awareness that this option existed and that it was available to her without consequence, the events of July 2, 2024, could have had a different ending. A newborn infant, surrendered safely at a Louisville hospital, could have been placed in foster care or adoption proceedings, could have had a life. The safe surrender law in Kentucky can be accessed through the Kentucky Cabinet for Health and Family Services. Hospitals across Louisville are designated safe surrender locations. Any Louisville Fire Department station is a safe surrender location. No identification required. No questions asked. 30 days from birth. The number to call for information is the Kentucky Child Abuse Hotline at 1-800-752-6200. Daira Mejia Aguilar was charged with felony abuse of a corpse in Jefferson County Circuit Court. The legal proceedings continued through the Jefferson County court system. The investigative record, the search warrant, the physical evidence gathered at the Zorn Avenue apartment and from the trunk of her vehicle, All of it stands as the evidentiary foundation of a case that documents one of the most silent and one of the most preventable tragedies in Louisville's 2024 true crime record. A full-term newborn. July 2nd, 2024. Zorn Avenue. A life that was contained entirely within the hours between birth and concealment. A life that the law recognized and that the justice system responded to with the seriousness that every life, however brief, demands. If this case moved you, if it made you think about the importance of awareness, of access to resources, of the community support systems that exist to prevent outcomes like this one, please like this video, leave a comment, and subscribe to Cold Case Hour. Share this video so that more people know about Kentucky's safe surrender law. Knowledge saves lives. Like, comment, and subscribe.